Ladies and gentlemen, let's have a nice warm welcome, a nice Scottsdale welcome for our instructor tonight, Augustus Shaw of Shaw & Lines. Let's welcome him now to the stage.
Oh my, that's a lot. Well, good evening, everyone. My name is Augustus Shaw with Shaw & Lines. I want to make sure that we are all ready for this, so you guys should all have a copy of this. This is the materials for tonight. This is a standing room only class, so if you do not have a copy of the materials, you can find the materials on my website, www.hoagui.com. It's going to be contained in the document, the 2019 Summary of Arizona Homeowner Association Law. Also, this is a unique type of presentation where I can't look at you guys in the audience, I have to look at the camera. So I usually like to engage the audience, but if I'm not looking at you, it's because I'm looking at the camera, because that's what they tell me to do. A little bit about myself. I've been practicing law for 19 years. I'm a product of the University of Arizona, both undergrad and law school. So the only school that I can root for are the Wildcats. Bear down. And despite what they will tell you, it's not U Arizona. They can market that whatever they want to. It's the U of A. I've been practicing in the homeowner association area for that long. I'm a member of the Community Association Institute College of Community Association Lawyers, and I also teach community association law classes for both local and national audiences. So I do a lot of these classes, and the reason why I do these classes is, as you may have heard before, at one point in my life I wanted to be a dentist. And so if you do what the dentist tells you, if you brush your teeth, if you floss, if you avoid Coke and sweets and such, you won't have to go to the dentist. Well, it's my singular mission to provide as much information to community associations and their members as possible so that I can retire someday. That's the goal, is to live my golden years on some golf course somewhere, taking lessons and trying to lower my handicap. But today we're going to talk about enforcement, how to effectively enforce the association's covenants, conditions, and restrictions. One of the major functions of a community association under law is the enforcement of the restrictions. This is also, outside of assessment collection, is the most controversial aspect of community associations. If you go to anyone on the street and you say, what do you think about their HOA? The odds are that they're going to say something to the effect of, they send me a letter when I leave my trash can out, and I don't like that. Or, I'll have a weed for 1 second, and the guy in the car will come and yell at me. Or, why am I getting a fine for my weeds, and my neighbor's house has weeds up to my knees, and they're not getting any fines? The important part in all of this for everyone to understand is that without enforcement of the restrictive covenants, there would be no community association. The whole singular purpose of a community association is to add an additional level of restrictions, more encompassing than what you would get with the city, in order to create a specific type of living environment. So enforcement of the restrictions are very, very important, and we're going to talk about those very quickly. But before we do that, we have to get some defined terms. We have to understand some of the legalese that I'll be saying to you, because unfortunately, as a lawyer, I will use terms of art. And because we can't do questions freely, I'll have to make sure that you understand the terms of art. So the first term of art is going to be the CC&Rs or the declaration. The CC&Rs or the declaration. That is the document, the covenants, conditions, and restrictions, that's recorded with the applicable county recorder, in this case, the Maricopa County recorder, that will contain the restrictive covenants. Now, what is a restrictive covenant? A restrictive covenant is a promise by you when you move into a homeowners association to restrict your rights. It's a promise by you to restrict your rights. Under Arizona's Constitution, we all have what's called the freedom of alienation in regards to our property, which means that we can use our property freely here in Arizona pursuant to the Constitution, unless we promise to restrict our abilities and rights under the Constitution here in Arizona. And that's what a restrictive covenant is. It is a promise to restrict the rights of a homeowner to their property. And those restrictive covenants are found in the CC&Rs or the Declaration. Now, flowing from the CC&Rs and the Declaration is the rules and regulations. In the vast majority of community associations in Arizona, the rules and regulations are developed by the board of directors only. Now, the rules and regulations cannot contradict provisions of the CC&Rs. Now, here I have to be careful, because I'm actually currently in a lawsuit that is arguing my very words. And what I mean by that is, what I mean when I say the rules and regulations cannot contradict provisions in the CC&Rs. What I mean by that is that if there is a provision written with words in the CC&Rs, the board of directors cannot create a rule that would be in opposition to that specific provision. Now, the board of directors, through the rules and regulations, can create rules that explain an ambiguous provision, but it cannot contradict the provision. Let me give you an example of that. Let's say the CC&Rs have a provision in them that says no on-street parking from sun up to sun down. Now, luckily for us here in Arizona, the world revolves around us, so we don't follow daylight savings times. But when the seasons change, so does the time that the sun goes down. So in the summer, I can usually get 18 holes of golf in. If I start about 4, I can get 18 holes in because the sun will go down about 7:30. Now I have to leave work early about 1 o'clock to get 18 holes in because the sun goes down about 5:30. So when you have a provision in the CC&Rs that says no on-street parking between sunrise and sunset, what does that mean? We have an ambiguity. This gives the board of directors the opportunity to explain the meaning of the provision. For example, the board could say that there shall be no parking on the streets between 7 a.m. and 7 p.m. Well, that time frame covers sunrise and sunset. So the board of directors can give you a specific time frame to explain the term sunrise and sunset. So that is the function of rules and regulations. They're never to add restrictions. So for example, using the same sunrise and sunset provision. If the provision in the CC&Rs says no parking between sunrise and sunset, the board of directors could not then create a rule that says no overnight parking. Because again, overnight is different from sunrise and sunset. It's in opposition to it. So the association's board cannot create a rule that is in opposition to a written provision of the CC&Rs. The board of directors, in most cases, can create a rule that explains provisions in the CC&Rs. And I hope that example was helpful. If not, we'll come back and talk about it during the question and answer period. The next document is the architectural guidelines. Now, these are the guidelines created again by the board of directors or the architectural review committee that provides guidance regarding the exterior presentation of a home, what colors you can paint your home, what can your yard look like. Some of my clients even go so far as to comment on the type of grass you can install. or the type of flowers you can plant. Again, this document flows from the CC&Rs provision requiring association approval for exterior changes. So because the CC&Rs says that you are required to receive association approval for exterior changes, that allows the board of directors to create architectural guidelines. So, to sum up, we have CC&Rs or the declaration, we have rules and regulations, and we have architectural guidelines. Now, notice that there are some documents that I did not mention there that you're kind of probably thinking about in your head, such as the bylaws or the articles of incorporation. Well, that's a class for another day, but to be brief, the bylaws and the articles of incorporation are dealing with the non-profit corporate entity of the association. So those documents govern how that corporation is to be operated. It does not govern how an owner can use their property. And that's the crux of our discussion today. How can you, as a homeowner in a homeowners association, use your property? More to the point, how can the association make you follow the rules and regulations that are contained in the CC&Rs, the rules and regulations, and the design guidelines? So why do associations enforce their restrictive covenants? Because they have to. Under Arizona law, there are court cases out there that suggest that a community association has an obligation to enforce their CC&Rs. This is also an obligation that is placed upon the board of directors as a part of their fiduciary duty. As I said in the very beginning, one of the main reasons community associations exist is to have a set of rules and regulations that everyone follows. Well, if there is no enforcement of those rules and regulations, then no one will follow them. Well, I won't say no one. There are good people out there that will do the right thing. However, I've been employed for 19 years because there aren't. And so we'll just say some really good citizens will follow the rules and regulations without motivation. But there are some that won't. And so there is case law, and what case law is, it is law that is interpreted by our state's Court of Appeals or Supreme Court. Those are courts of review in Arizona. Cases where the Court of Appeals or the Supreme Court, they've reviewed the law in a certain area and they've provided additional guidance on how that law is to be interpreted. In this case, the law is being interpreted to include a suggestion, a strong suggestion in some aspects, a requirement in other aspects to enforce the restrictive covenants. And again, whether you are required to enforce them versus highly suggested to enforce them will depend on the wording in your CC&Rs or your declaration. But suffice it to say that it is critically important and could be a legal liability for a board of directors to fail to enforce the provisions of the restrictive covenants. Now, as my mom would always tell me when I was growing up, just because you can do something doesn't mean you should do it. And that's an axiom that I've lived my life on. Just because you can do something doesn't mean you should do it. More appropriate to our conversation today, know what you can do and how you can do it before you do it. Don't just jump and do something. Understand what you're doing and how you're going to do it before you do it. So when it comes to enforcement of restrictive covenants in community associations, it's important that the association, especially the board of directors, understand how to effectuate enforcement. And the reason, and some of the tips that you can use is, What enforcement action is permitted under the governing documents? What tools do you have in your tool chest to motivate owners to comply with the restrictions? What enforcement action is permitted? What can you do? Next, of all the things you can do, of the enforcement methods, which one is likely to gain compliance? This one is critically important if this matter should ever go to court. Courts don't like it when you use a machine gun when a paddle would be more appropriate. Moreover, courts don't like it when you use a paddle when a machine gun was more appropriate. Now, those are extreme examples to highlight the point that whatever enforcement mechanism the association is going to use, it must be geared to gain the desired compliance. It doesn't make sense to engage in an enforcement activity that's not going to gain compliance. And let me give you a personal example. Well, we're recording this, aren't we? Okay, it has nothing to do with me. Let me just give you an example. Not me. Wink, wink. So, prior to my father-in-law passing away, my father-in-law and I, we he built, I watched him build and kind of swung a hammer every now and then, a cabin in northern Arizona by Ash Fork, Arizona. We have a 40-acre kind of family spread ranch out there, and he designed and pretty much built the cabin. While we were doing that, we had a fifth wheel, because we would go up there for a weekend or for a week. We would drive the fifth wheel to the property. We would work on the cabin, then we'd sleep in the fifth wheel, and we'd work on the cabin, and we'd sleep on the fifth wheel, in the fifth wheel, and we would drive it back down to the valley. Well, I live in a private gated community that has a restriction that says you may not park an RV on the roads, period. Okay, fair enough. But the fine for that was $50 a month. Now, to store my fifth wheel in the storage yard a mile away was $150 a month. So you think to yourself, I can pay $50 a month to my HOA, or I could pay $150 a month to the storage company, and I can look out my window every day and make sure my RV is safe. I can clean it whenever I want to, versus having it at a storage yard. Who knows what's going on there? Who knows what kind of security they have? And it's $50 versus $150. I'm saving $100. Let's park it in the front. Now, if my HOA is just going to fine me $50 and I'm saving $100 on the deal, why would I comply with the restrictions? Now, I'm a good guy. I'm one of those rule followers. So I would follow the rule, of course I would. But some people would make a strictly monetary decision there. What does that highlight? The mode of enforcement did not gain compliance. So you may want to choose a different mode of enforcement. So you first determine what mode of enforcement can you use. Next, you determine which mode of enforcement is going to gain the desired result. The third thing you consider is, what is the most reasonable method of enforcement under the circumstances? You don't impose a $500 a day fine for a trash can, right? You don't sue someone over a weed. You have to look at which one of your tools is going to be reasonable to use in this certain circumstance. And again, these three questions that I'm highlighting to you are based on my experience in courts around the state of Arizona litigating enforcement issues. I've been blessed to have a practice that takes me from Bullhead City, Arizona to Douglas, Arizona, from St. John's, Arizona to Parker, Arizona. I cover the entire state. I do a lot of driving, and I love this state. I was born and raised here in Arizona. My wife was born and raised here in Arizona. In fact, I'm the fourth generation. My name is Augustus Shaw IV, so I'm the fourth generation Arizonan. I have a 15-year-old son, not named Augustus. His name's Ezekiel. A 12-year-old daughter, and I've been blessed with a now 3-year-old son. So he was our happy surprise. And so when he was being born, I looked at him and I said, "Little happy surprise, I'm going to burden you with the name. So you are now Augustus V." So he can say that he's the 5th generation Arizonan. But I love Arizona. And I've practiced throughout this state. And these 3 thoughts are thoughts that the judges consider when looking at enforcement actions brought by community associations. So, very important that before an association thinks about writing a letter, or more importantly, thinks about creating an enforcement policy, something else that we'll discuss very quickly, that any enforcement policy is based on these 3 principles. Now, so you ask yourself these 3 important questions. The next question you have to ask yourself is, well, is the document that I'm trying to enforce enforceable? Is the document I'm trying to enforce enforceable? Another great saying that my mother gave to me is, the only constant is change. Things change. Nothing stays the same. And that axiom really applies to community associations in Arizona. Every single year, the legislature gives us new laws that affect community associations. Whether that be good or bad, I'm not here to say. The point that I'm making is that the restrictive covenants can change by action of our legislature. The restrictive covenants can also change by action of our court system. So, if you have a set of CC&Rs that were written in the 1970s, they may not be enforceable in 2019. If you have a set of rules and regulations that was created in 1999, it may not be enforceable in 2019 because the law changes so quickly in the HOA arena. That's why it's important to have your CC&Rs, your rules and regulations, your architectural guidelines reviewed every 5 to 10 years to make sure that what you think is enforceable is actually enforceable. Now, of course, if you have a good attorney, your good attorney, before filing an enforcement lawsuit, will say to you, hey, you can't do that. And hopefully you'll listen and you won't do it. Or hopefully the attorney will have the intestinal fortitude to resign as counsel if you make him do it. But it still is a good idea to have your documents reviewed every 5 to 10 years. Now, notice I didn't say changed. I didn't say amended. I simply said reviewed. Because if you have a good set of rules and regulations, and you have a good set of CC&Rs, the likelihood is you may not be required to change them. You still, however, want to have them reviewed just in case. Next, and very important for everyone here in the audience and in TV land to understand, is you must have a policy on enforcement, an enforcement policy written down, approved by the board of directors in an open and noticed meeting of the board where an agenda is being made available, not an executive session, not over email, an open noticed board meeting where an agenda is made available. An enforcement policy is critical. Why? It explains to owners the rules of the game. More importantly, as was pointed out to me several years ago by a very fine Pinal County judge, the owners are placed on notice regarding what could happen to them if they don't follow the restrictions. When it comes to community associations in Arizona and the court system, the fundamental principle is, did the owner know? Was the owner aware? Did the association provide the owner with notice that A would happen to them if they did not do B? Did the owner know that if they didn't pay their assessments on time, there would be a $15 late fee? Did you tell them that? Is there a policy regarding that somewhere? Does the owner know that if they violate the restrictions, there will be a $100 fine imposed? Do they know this? How do they know this? How did you tell them? You tell owners, you place owners on notice through a written enforcement policy that is provided somewhere, either provided on the website or given to the owner at the close of escrow, or as I like to suggest, given to the owners every single year when you send out your annual meeting packet. If I can go into court and prove, A, the owner had noticed that if they didn't comply with the restrictions, we would be in court, and B, the association used the appropriate enforcement mechanism, and C, we did everything pursuant to the law, I'm going to win every day. I'm going to win every day. But all of that starts with a written enforcement policy. So all of you out there in TV land, if you do not have a written enforcement policy, please go to your professional manager, or please go to your attorney or your executive director and say, hey, that guy on TV suggested we have an enforcement policy. The reason why I can say that is there's absolutely no downside to having an enforcement policy. None. But the upsides are immense. So we start with an enforcement policy. And just like the CC&Rs, just like the architectural guidelines, just like the rules and regulations, that should be reviewed every 5 years. Let me see, how are we doing on time? Oh, we're doing great on time. Okay, good. For those of you in TV land, if I look over here, the clock's over here, so that means I'm looking to see how I'm doing on time. Now, just to recap, we know what the documents are that we need to enforce. We know that those documents should be reviewed every 5 years. We know the 3 important questions that we should ask ourselves when we're preparing to enforce. Now let's talk about the specific modes of enforcement. What can a community association in Arizona do to make you follow the rules and regulations and the restrictive covenants? The first most common enforcement method is the imposition of a monetary penalty or a fine. The imposition of a monetary penalty or a fine. That is by far the most common enforcement method here in Arizona, and I dare say across the country. The next one is filing an injunctive lawsuit, an injunction lawsuit, requesting that the court order the owner to come into compliance with the restriction. That's a situation where you'll have to go hire an attorney. The attorney will go to court and says, Your Honor, please order this person to do something. The court will look at the evidence. The court will look at your policies, your procedures, the way you handled the enforcement, and the court will say, okay, Mr. Owner, I order you to comply with the restrictions. The third mechanism is a mechanism that not every association can use. And this method is self-help. And that is when the association goes onto the property of the owner in violation and remedies the violation. Now, not every association can take advantage of this method. Only associations where their declaration, their CC&Rs, provide them with the specific authority to engage in self-help, only those associations may engage in self-help. So self-help is not something that every homeowner association or community association can do, unlike fines, unlike injunctive relief. So we are now going to take a very deep dive into these enforcement mechanisms, okay? We're going to start with the hardest one first, and that one is the imposition of a fine. Now, I will say in my 19 years, the reason why homeowner associations have a bad rep is because of the imposition of fines. Either because owners feel that the fines are unfair, or because owners believe that the behavior that is a violation does not rise to the level of a monetary fine, or because owners just don't like to be told what to do. In any event, fines are a convenient and easy target to bash homeowner associations in Arizona, which is fair. However, if you simply follow the real simple steps that we're going to talk about here today, I can say with certainty that fining will not be an area of disdain in your association. So, how do we do that? How do we turn fining from being disdainful to acceptable? The first thing we must do is understand the law in Arizona regarding the imposition of a fine. Now, this law is more clearly detailed in the handouts that the audience has here. I referenced the Planned Communities Act, I referenced the Condominium Act, and cases that deal with fining. For those of you on TV, if you want to go to HOAguy.com, go to the publications section and look in the 2019 summary of homeowner association law. What we're going to talk about is contained in that document with the specific statutory references. HOAguy, HOAGUI.com, publications, 2019 summary of Arizona homeowner association law. So the statutes in Arizona, the Condominium Act and the Planned Communities Act, requires that if a community association is going to impose a fine, there's a litany of steps that must be taken before that fine can be implemented. Now, the best thing to do, the best way to follow Arizona law is to have an enforcement policy where all of this is laid out. That's the best way to handle it. But let's talk about it. So first and foremost, a monetary penalty or fine must be reasonable. That term, reasonable. That's probably why I do not sit on the Supreme Court right now, or I'm not teaching at Harvard. I did well at the University of Arizona. Well, I obviously graduated, but I did pretty well at the University of Arizona. But we had a constitutional law class, and that pesky term reasonable came up. And the question was, what is reasonable? And being a young, wannabe attorney, I tried to answer the question. Now, after 19 years of being an attorney, I understand that I can never answer that question. Because the reality of what is reasonable, the reality is, reason is in the eye of the beholder, or the trier of fact. So in other words, whatever the judge says is reasonable, that is what's reasonable. None of us can comment on what is reasonable because none of us are going to be in the judgment seat when a judge is looking at a fine to determine if it's reasonable or not. So the statute says a fine must be reasonable. How do we ensure that the fine is reasonable? Well, we go back to what we think about when we enforce restrictive covenants. What mechanism of enforcement is going to motivate the owner to come into compliance? Same thing with the fines. What amount of fine is going to motivate the owner to come into compliance? Go back to the example of the fifth wheel. A $50 fine was not going to motivate me to come into compliance. So it wasn't necessarily reasonable. On the flip side of that, a $1,000 fine would have probably caused me to flip out. That would be unreasonable. So when you're looking at fine amounts, you want to look at several factors. Where do you live? What community association do you live? What's the average income of the association? Ask yourself, if someone imposed a fine of X on me, how would I react as a board member? Would I be like, whatever? Would I be like, that's crazy, I hate this HOA? Or would I be like, well, okay, I guess I better stop parking in the front. I guess I better move my RV. Professional management can help you with that. I'm an advocate of professional management. Those guys have decades of experience in dealing with fines. So professional management is a good way to get some guidance in regard to what reasonable is. If you don't have professional management, your local HOA attorney can help you out with that. But you never want to have a fine that's ridiculous, either on the high end or on the low end. Ridiculously high or ridiculously low. You want to avoid that. Now, as I said a few moments ago, before an association imposes a fine, and now I'm going to get on my soapbox. What does the imposition of a fine mean? When the number goes on the ledger, the fine has been imposed. We all have customer ledgers. In fact, there's a law that will take effect in January that says that all of us will get copies of our customer ledgers or our statements of account. When a fine touches the statement of account, it has been imposed. Prior to the fine touching the account statement, the owner must be provided notice and an opportunity to be heard. Notice and an opportunity to be heard before the fine hits the statement of account, not after. So you can't put the fine on the statement of account and then say, you have been fined $25. If you want to talk about it, come to the board meeting. That's an automatic violation of the Planned Communities Act and the Condominium Act and case law in Arizona. Before a fine is imposed, notice and the opportunity to be heard must be provided. And that's so very easy. Before you impose a fine, because you're going to have to send a letter saying you've been imposed a $25 fine, before you send that letter, well, there are going to be some other letters you have to send, and we're going to talk about that. But before you send that letter, send a letter that says, if you do not come into compliance within X amount of days, a fine may be imposed and placed on your account. If you'd like to talk about your violation or the potential for a fine, please contact Augustus Shaw within 5 days of the date of the letter. Now you've provided the owner with notice that a fine could be imposed, and you've given them the opportunity to discuss with someone the fine. Notice and an opportunity to be heard. Again, as I said earlier, courts, all the courts care about, well, one of the very important things that the courts care about is, Does the owner have notice of what you're going to do to them? Have they been placed on notice? Before you do it, did you tell them that this was a possibility? Again, we do that through a fine policy, but we also want to do that in writing before we impose a fine. Now, the statement imposing the fine, you have been fined $25, must also include a statement as to how you're going to collect that fine. If you don't pay the $25, we're going to send you to the attorney. If we don't pay the $25, we're going to jump up or down and scream. I don't know. But you have to tell them how you're going to enforce that, how you're going to collect the fine. What's the best way to do that? Simply say, if you fail to pay the fine, we're going to collect the fine pursuant to our collections policy. Collections policy? Yes. In addition to an enforcement policy, every association should have a collections policy, placing the owners on notice of how you're going to collect assessments and fines before they become delinquent. It's called policy governance. And one of these days, Bruce, I think I want to teach a class to my friends in the city of Scottsdale on policy governance. Because policy governance is the way that community associations should govern. It'll make board meetings an hour long. Wow, what? Huh? Oh, an hour-long board meeting? What? It'll make board meetings an hour long. It'll place responsibility where it needs to be placed. And it will place all owners on notice regarding how their association is going to operate. So maybe in the future, if Bruce and the wonderful people of Scottsdale allow me, we'll teach a class on policy governance. But all that aside, you want to have a statement telling the owner how a fine will be collected when you impose the fine. Now, as I said, just because you say a fine amount is reasonable, just because I, as an attorney with 19 years experience, says that the fine is reasonable, doesn't mean it's going to be reasonable. It's my best guess. Again, the reason why I'm not teaching at Harvard Law is because I missed the question, and the question was, what is reasonable? Whatever the court says is reasonable. I can argue both sides of every issue. That's what an attorney does. But ultimately, it's going to be the judge, the court, that's going to say, I agree with that argument, it's reasonable. Or I don't agree with that argument, it's not reasonable. So you try your best. You try your best. You place the owners on notice of the fine capability and the fine amounts through a fine policy, and you try your best to do the right thing. Now, as I was commenting on, reasonable, unreasonable, what do we do? It leads to confusion. So one of the ways that we can deal with the confusion is, again, placing the owners on notice of not only when a fine will be imposed, but the amount of the fine. The amount of the fine. For example, failure to maintain your landscaping will result in a $50 fine. Okay? If the owners are aware of the fact that failure to maintain their landscaping will result in a $50 fine, they're placed on notice of it, that helps with it being reasonable. There will be a $100 fine for parking an RV on the streets. Again, you place that in a policy. Owners are aware of it. They're placed on notice of it. It helps with the argument regarding whether the fine is reasonable. Now, did you hear what I just did there? I had differing amounts for differing violations. That's counterintuitive, isn't it? Shouldn't every crime have only one remedy? So if I steal a car, or if I engage in assault or anything like that, shouldn't I only go to jail for one period of time? Because every penalty, every violation should have the same penalty, right? So if that, and people in the audience are shaking their heads. So if that doesn't make sense on a societal level, how does that make sense on an HOA level? How does every single violation, the various ways you can violate your restrictions only come with one penalty, a $50 fine. Aren't some violations more important to the community than others? If I'm running a crack house in my house, wouldn't you want to motivate me to stop that faster than you would if I had a weed in my yard? If I painted my house hot pink, I like hot pink. If I painted my house electric green, or I left my trash can out, aren't those different? Don't they have differing effects on the community, on the value of the properties? So if they have differing effects on the community, shouldn't they have differing fine amounts attached to them? I don't know where we came up with the one-size-fits-all when it comes to fines, but I don't think it's reasonable. I don't think a $100 fine for a weed and a $100 fine for running a pig farm in your backyard, should be the. I don't think those violations are the same. And so maybe one should consider the appropriate method to gain compliance. A $50 fine for a weed may be appropriate. A $50 fine for parking an RV on the street may not be. So this is going to take us right into the fine policies. And as I've been saying for the past 10 minutes now, fine policy, fine policy, fine policy, have a fine policy, have an enforcement policy. Now, obviously, you should have help drafting a fine policy, especially if you're going to charge people money or take people to court pursuant to that policy. So you should have an attorney review it to make sure that it is legal, make sure it does what you want it to do. Because if you have a fine policy that doesn't accomplish your goals, then it's a waste of paper. Now, some suggestions. The great thing, one of the best things I love about being a lawyer is I get to argue both sides of every argument. So today I can tell you the sky is blue. Tomorrow I can tell you the sky actually has no color. And I can argue both sides of that story. Well, what do you mean, Augustus? Well, why is the sky blue? You guys probably know this, right? Because the sun reflects off of the ocean, and then the color of the ocean reflects back, and it's actually an optical illusion. However, I can look at the sky, and in my third grade mind say, that looks like blue. So it doesn't matter what the optical illusion is, the sky is blue. I observe it to be blue. But then I can argue scientifically it's not blue. Argue both sides of an issue. So the suggestions that I'm giving you are suggestions. They're not black letter law. It's not the lay of the land. Differing attorneys will differ. But I can say that in my experience, some of these key aspects are important. And a little bit about my firm to help you out with my experience. About half of what my firm does now is insurance defense, which is we defend community associations when they are sued by their owners and others, but mostly by the owners. So that's half of our practice. The other half of our practice is providing community associations with legal advice regarding a myriad of their legal needs. So in having a practice that's 50-50 like that, we get to see when our advice, how our advice has an effect when it's litigated. So the examples that I like to give in my classes are examples of litigations that I have lost so that you don't have to go through that pain. So what are one of those suggestions? One, avoid escalating fines. What's an escalating fine? The first fine is going to be $50. The second fine is going to be $100, and the third fine is going to be $150. Why should you avoid escalating fines? Remember our question? Choose the enforcement method that's going to gain compliance. It shouldn't take you 3 times to come up with a fine amount that's going to gain compliance. It should take you 1 time to come up with a fine amount that's going to gain compliance. What is the goal of imposing a monetary penalty? It's not to supplement your budget. It's not to supplement your budget. It's to gain compliance quickly. So if an owner's going to ignore a $50 fine and you have to go to $100, you're using the wrong mode. Or the fine amount isn't reasonable because it's not gaining compliance. If you have to go to $100 the next step, again, the fine isn't reasonable. You're not gaining compliance. What happens if you go to the escalating $150 fine and you still don't get compliance? What do you do then? Do you keep going until you hit a number that's going to gain compliance? A court would say, why didn't you just start with the number in the first place? Impose the fine that's going to gain compliance, because that's what your goal is. So escalating fines, I would scrap them because they may not be reasonable. The other side of that coin would be you want to have some mercy. You want to get their attention without beating them over the head and shoulders. So we're going to start small, then we're going to go up a little bit, then we're going to go up a little bit to let them know we're serious. Well, you could do that without imposing a fine. You can do that through letters. Hey, a courtesy notice. Hey, we're neighbors. Please bring your trash can in. Thank you. They don't bring it in. A second notice. Hey, we sent you a first notice. You didn't bring your trash can in. If you don't bring your trash can in, again, we may impose a fine, but hey, come talk to us about it. Here's a name and number that you can call to talk to us about this issue regarding the trash can. Because again, my friends, you never know why someone is engaged in a violation. They could be belligerent, or there could be something wrong. There could be a medical emergency. There could be a family emergency. So you always want to give them the opportunity to let you know, because it's the law and it's the right thing to do. Then a third letter that says, okay, we're imposing a very stiff fine on you. Please don't make us sue you. And then the next step would be a lawsuit. Not, we're going to fine you $50. We're going to fine you $100. We're going to fine you $150. That's called fining into oblivion. Courts hate it. The worst thing you can do in court is walk into court with a $5,000 fine amount. Judge is going to look at you and say, okay, so what's the fine? Your Honor, it's $50 a month. How long have you been living with this violation? A couple of years. Never occurred to you that maybe you should do something else besides fining? And since the fine didn't motivate the behavior, and since you sat on it for a while, I don't think the fine is reasonable, so I'm not going to award it to you anyway. I mean, what's the harm? You don't plan your budget on fine income, do you? I actually had a judge say that to me. How do you respond to that? My response was, well, Your Honor, we don't want to haul people into court. We just want to work with them, and that's why we impose fines. The court's response was, sometimes you got to do what you got to do. You can't sit on a violation and fine someone for 2 years and then come to me and ask me to give you 2 years worth of fines. After a couple of months, you may want to think about which enforcement method is going to gain compliance. Oh, that's very wise, Judge. I guess that's why you're the judge and I'm not. As I said earlier, consider having differing fine amounts for differing violations. One of the ways that a fine is reasonable is that it can be directly tied to a harm that the association may suffer. In the example of an electric green, a puke green, actually no, I have a puke greenhouse in my association, so I won't go there. Super University of Oregon Donald Duck greenhouse. How will that affect the other homes in the community? If you had a house next door to that, Would it affect the way you sell your house? Would it affect sales in your house? If that's a possibility, then you may want to have a fine that matches that possibility, versus living next door to someone who leaves their trash can out a couple times a year. I don't think someone's not going to buy a house because there's a trash can left out one day before the trash pickup. Someone may make a decision about living next to a University of Oregon greenhouse. Nothing against University of Oregon. They always beat the Wildcats in football, so I don't like them, but it's still a good school. So you should consider having differing fine amounts for differing violations and list those fine amounts in a fine policy so owners will know that this violation has this fine and this violation has this fine. Again, all we're doing here is trying to satisfy 3 statutory requirements. 1, that the fine must be reasonable. 2, that you must provide notice of the fine and an opportunity to be heard. And 3, you must provide information on how the fine is to be collected. All of these things I'm telling you here are to try to bring yourself into compliance with those statutes. Now, I'm going to go back a little bit. So let me put a bow on the fines and the fine policies. You want to have a fine policy and enforcement policy that's reviewed by your attorney. You want to make sure that that fine policy lists every aspect of enforcement. When a fine will be imposed, how much that fine will be. Is litigation, is injunctive relief an option? Is self-help an option? You want to have all of this in a fine policy, and you want to give this policy to your owners, or you want to post this policy on your website or somewhere else where owners can readily see it. That will help us with the reasonable argument, and that will help us with the notice argument. Okay? So let's wrap up that discussion on policies. Now, before you can impose a fine or send an enforcement action to the association's attorney, you must provide, again, as I've been saying, notice to the owner. Now, an owner has the right under law, 10 days the owner has a right pursuant to law to obtain certain information from the association if the owner sends the association a certified letter within 10 days of receipt of a notice of violation. Now, if the association does not send, not 10 days, I'm sorry. There's a typo on the screen. It says within 10 days, but it's actually 21 days. My apologies on that. Sorry, Bruce. It's within 21 days. My apologies. The old law was 10 days. Now it's 21. So the owner can request certain information. And before you provide that information to you cannot impose a fine until you provide that certain amount of information to the owner. So what information must be provided? 1, the provision of the governing document or the rules and regulations or the architectural guidelines that's been violated. 2, the date of the violation. 3, the process by which the violation can be appealed. And 4, and this is the big one, the first and last name of the person who observed the violation. Now, there is a healthy debate regarding this law in Arizona. And the healthy debate is, should an association, when sending the first violation notice, list all of this information in the first violation notice? If you do that, then you're free to impose a fine, or you're free to send the account to an attorney, because you've met the requirements of providing an owner with the information required under the statute before the owner asked for it. Remember, the statute says that the owner has to ask for it via certified mail, then you give it to the owner. But the owner has 21 days, right? So let's say your initial courtesy letter says, remedy the violation within 7 days, or we may impose a fine. So 7 days passes, you're on day 8. Remedy the violation, or a fine will be imposed in 7 days. Right? So now you're on day 15. Oops, you can't do that. Because the owner has 21 days to send you a certified letter asking for the required information. So what the effect of the law is to require associations to wait the full 21 days in anticipation of the owner requesting the required information via certified mail. So if an association doesn't want to wait the 21 days, then provide that owner the information in the first notice and every subsequent notice. Now, for me, that makes sense except for one little hiccup: the first and last name of the person who observed the violation. So let me relieve everyone in the audience and in TV land of any trepidation you may have regarding that statement, okay? I can't win a lawsuit without a witness. So if you're unwilling to put your name on a violation, if that violation eventually goes to court, I'm going to need you to testify to the violation. You saw the violation. You're the one who reported the violation. If no one else saw that violation and no one else reports that violation, how do I prove the violation happened? I can't. So what I advise my clients is, if an owner wants to be anonymous, either you have someone who doesn't want to be anonymous go and verify the violation, or there is no violation. If an owner calls in and says, oh, that Augustus Shaw, he's parking his fifth wheel in front of on the street again. Okay, great, what is your name? Well, I don't want him to know. You know, we watch U of A football together. I don't want him to know. Then the manager can say, okay, that's fine. I'll drive by tomorrow, and if the RV is still there, I'll be the one who saw the violation. I'll send the letter. Easy. Or the manager could say, well, can you just ask your next door neighbor to go out there and look at it, and maybe he'll put his name down? Or the manager can say, well, I'm sorry, but you know, if we have to litigate this, you're the only person seeing this violation. If you're not willing to put your name on it or testify, then we're going to be unable to prove the violation. So we're not going to even go through the endeavor at all. So some people get hung up on that. And that's my response to the individuals. You know, I've had one owner tell me, well, but what happens if I take a picture and send it to the manager? Well, that's proof, isn't it? Well, unfortunately, under the law, we have to what's called authenticate a photograph. So we actually have to have the person who took the photograph testify to the photograph in order to bring the photograph into evidence. So I'm still going to need your name to get it into evidence. But you're not going to sue this guy over this violation. Why do you need to put me through all this grief? True that 99% of the violations in Arizona are rectified with a simple fine. It's that 1% that allows me to have a thriving practice in Arizona. And trust me when I say, if I can tell you about the example, I must have lived the example. It's kind of hard to prove a case when you don't have a witness. And so what I tell my association friends is, look, you know, I love being your attorney, and I'm not to brag, but I'm good at what I do, but I can't even win a case without evidence. Got to have evidence. And if your owner or the person who saw the violation is not willing to testify, how do you think I can prove your case? I have no evidence. So one suggestion to help you to aid in speeding up the process is to provide the pieces of information that the statute requires early. And again, if you don't want to do that, hey, that's fine. That's fine. But it's advisable that you wait the 21 days before you impose a fine or send the file to an attorney. How are we doing on time? We're doing pretty good. Okay. Sorry. So before I leave fines, I just want to sum up the key points when it comes to a fine. First, a fine must be reasonable. Some of the ways that you can help a judge feel like your fine is reasonable is by having differing fine amounts for differing violations. You can also help a judge feel that your fine is reasonable by having a schedule of fines in an enforcement or fine policy and making sure that that enforcement or fine policy is disseminated to all owners in the association or is readily available on a website or some other public forum. Always provide the owner with an opportunity to discuss a fine before the fine hits the statement of account. I suggest that in every letter you send the owner, you say, if you'd like to talk about this violation, please call this person at this number. Every single letter that you sent. Because that way you can show a court, we're always willing to talk, Your Honor, but they won't talk to us. We're always willing to talk, but they won't talk to us. Okay? And then if you want to have a more expedient enforcement process, look at providing the information under the statute, the provision of the governing documents, rules and regulations, or architectural guidelines that have been violated, the date of the violation, the process to appeal the violation, and the first and last name of the person who saw the violation. And quite frankly, guys, that should be on every single letter from a litigation standpoint and from a neighborly standpoint. Help your owners to not be at odds with your association. Help them. Send them a courtesy notice that says, hey, you may not have known this, but you can't leave your garbage can out. Here's the specific provision of the CC&Rs that says you can't leave your garbage can out. Now, hey, maybe you had a weird situation. Come talk to us about it. And this person saw the violation, so you do not think we're making this up. You do not think we are picking on you. You do not think that we hate you because you're special. We don't hate you. This person is seeing the violation. Help your owners. It's not a defense, it's an excuse. But the most prevalent excuse that I get when I go to court is, I didn't know I had to do that. Well, did you read your CC&Rs? Who reads the CC&Rs? Who reads 48 pages of legalese? Even though, you do have to sign a statement when you buy your house that says, I read and I've read the CC&Rs and understand that my house could be foreclosed pursuant to the CC&Rs. Now, that's a paraphrase for my TV audiences, but nonetheless, everyone says, I didn't read it. Well, unfortunately, under the law, that's not a defense. It's an excuse. But, again, we are in a community association. Let's build community. Let's educate our owners about the rules before we lay down $4,000 or $5,000 worth of fines on them, or before we sick that mean Augustus Shaw on them and go to court. So why not tell them, hey, this is the provision, this is when we saw it, this is how you can talk to us about it, and this is who saw it, so you can feel that, so you can know we're not picking on you. We just want to educate you. And if you can do all of those things, then the likelihood of your fine being reasonable, and more importantly, being accepted by your members, increases. Okay, now we're going to go to a little easier topic, which is injunctive relief. So, as I said, an injunction is simply a request of the court to order an owner to come into compliance. Now, hopefully, at least in my practice, the violation is of a nature that only the court can help you out with it. The violation is of a nature that only the court can help you out with it. Remember, what enforcement mechanisms do you have at your disposal? Which one is going to gain compliance? And which one is reasonable? Okay? The use of injunctive relief should only be used when the court is your only avenue of relief. And there are a lot of examples of that. For example, you've been imposing fines for a number of cycles and you're getting no response. You may need court help with that. It's an emergency situation. It's a pig farm. It's a drug house. It's a house that has been gutted by a fire and the owner refuses to repair it. Right? It's an owner who parks their fifth wheel on the street and refuses to move it. Those are instances where you want to seek an injunctive relief. Now, there's a fine line in injunctive relief. And that fine line is called equity. Equity is a fancy word for fairness. What is fair? And injunctive relief is a cause of equity, meaning you're going to the court in fairness. So when you're talking about equity, there's a lot of things to consider when you talk about equity, such as the relative hardship and injustices of the party. Let me give an example of this, painful example. Let's say I live in a community in northern Arizona, and I own acreages, right? And so I have a house there, but my mom, she wants to move up, and she wants to be close to the grandkids, especially the little 3-year-old. So she says, hey, you're a successful, rich attorney. Build me a nanny house. I want to live next to my family. So I say, well, people can't get along. I'm doing good in the HOA world, so I'll build you a nanny house. But, me being the sly HOA attorney that I am, I don't get association approval to build a nanny house. I just build it. What are they going to do to me? Fine me $50 a month? So the HOA sends me a nice letter. Hey, Augustus, we see you're building a nanny house. You got to get approval for the nanny house. So can you send us an application, please? Here's the section of the CC&Rs that says you have to do it. Here's how you can talk to us if you want to appeal it. And the manager saw the violation. I look at that and I laugh. Ha! I'm the HOA guy. And I throw it away. The association sends me a second letter. Hey, we hope you got the first letter, but just in case you didn't, if you continue to construct or you continue to build, we're going to fine you. So here you go. Again, I'm the HOA guy. I look at that and I laugh. Ha! I get a third letter from the association saying, if you do not apply for approval, we are going to sue you. And my response is, who are you going to get to sue me? Every HOA attorney in the state knows who I am. You're not going to be able to get anyone to sue me. Ha! And so the association says, well, we got to sue him. So the association hauls me into court. And the association shows the pictures of this beautiful nanny house. And they say, we don't have a record of the violation of receiving an application. And he admits that he didn't send an application. I said, yep, didn't send one. Didn't send one. And so they say, well, Your Honor, open and shut case. We rest our case. He's in clear violation of the restrictions. He's belligerent about it. Please order him to tear down his nanny house. We rest our case. So my very smart HOA attorney comes up and he says, okay, I'd like to put the board president on the stand. Board president goes on the stand. Mr. President, have you seen Mr. Shaw's nanny house? Yes. What do you think? Oh, it's gorgeous. It's the right color. It fits into the pine trees. You can barely see it from the street. You know, you kind of even wouldn't even know it's there unless you stand this way from the street, or you get on the neighbor's roof and you're looking down. But yeah, it's okay. So, Mr. President, if Mr. Shaw would have asked for approval, would you have given it to him? Oh, sure. Yeah, we have nanny houses all over the place. So why are you suing Mr. Shaw again? It's the principle. We have a restriction that says you have to get approval. He didn't get approval. We have to sue him. Okay. You're excused, Mr. President. I'd like to now put an expert on the stand. Mr. Expert, what do you do? I'm a real estate agent. Okay. Have you seen Mr. Shaw's nanny house? Yes. Would you say that the nanny house increases the worth of the property or decreases it? Well, it increases it. Would you say the nanny house increases or decreases the property values of all the other owners? Well, you know, it neither increases or decreases it. It just is. Okay. Thank you. You're dismissed. Bring on another expert to the stand. Mr. General Contractor, how much would it cost to tear this thing down? Oh, to tear it down completely? Yeah. A couple $100,000? Okay, thank you. Your Honor, we're here litigating on principle. The association has no damages here. They have not been harmed. The board president says that if the structure if Mr. Shaw would have asked for approval, he would have received approval. And the board president himself says it's a nice structure. Why are we here? Equity would suggest that although Mr. Shaw is in violation of the restrictions, the association hasn't suffered any harm. And if the association hasn't suffered any harm, what's the harm, Your Honor? Oh, and by the way, it would cost a couple of $100,000 to remove the structure. And his elderly grandmother wouldn't be able to spend her last remaining days with a 3-year-old, 5th-generation grandson. Now, you tell me, what is the judge going to do there? Is the judge going to say, I'm going to make you, Mr. Shaw, spend $100,000, kick your mother out for an ancillary structure that the board president likes, that would have been approved, and that doesn't detract from the property values of the association at all? Oh, and by the way, that can barely be seen? Just because you didn't apply for it? No, this is a court of equity. I'm going to allow you to keep your house, your ancillary structure. Now, I've litigated that, not personally, not me personally. I don't think my mother would want to be 5 feet from my little 3-year-old. He's a terror. But I've litigated that example, and I've litigated examples like that. When you seek injunctive relief, it's serious. The association has to show some type of harm, that the behavior that you're seeking the court to enjoin is harmful to the association, and the association either is or will be damaged. So let me give you an example of that. Owner builds a toy garage, right? Toy garages are allowed, but he builds the toy garage in the setbacks. He just ignores the setbacks and puts it 6 inches from the common area wall. So it violates the city setback, it violates the association setback. He didn't receive association approval, he didn't receive city approval. The building is so tall that it literally, if you're in the upper story of it, you can look down on the neighbor and see the neighbor's child's bedroom, who happens to be a 16-year-old cheerleader, by the way. And it's god-awful big, and it doesn't fit the nature of the community. So, association says, Augustus, please help us. This guy is just, these guys belligerent. So I go to court. I say, Your Honor, 1, the city is harmed here because it's built in the setbacks. 2, the association is harmed here because other owners are having their privacy invaded, and other owners were not placed on notice that this could be a possibility, that someone could build a structure in the setbacks. that would be tall enough to view into their 16-year-old daughter's room. They didn't buy a house here thinking that could even happen. So it violates the CC&Rs. And oh, by the way, Your Honor, if he would have asked us through an application, we would have told him to not build it in the setbacks. So it wouldn't have been approved regardless. Help us. And the owner's attorney says, well, Your Honor, it's going to cost $350,000 to tear this thing down. Balance of the hardships, economic hardship. Okay? I bring the parents of that 16-year-old cheerleader in, and they testify that there's really no way, through blackout curtains or whatever, there's no way that they can stop this person from seeing into this little girl's bedroom. And again, there are rules in the CC&Rs regarding building in the setback. So we, when we bought our property, relied on the fact that no one would build in the setback. Balance of the hardship. Owners are damaged. The association's damaged. There's no notice of the possibility of this happening. Tear down your $300 ancillary structure. So what do I say? I don't take an injunction action to court unless I'm going to win, because you should win every injunction action. Because you should be able to present evidence as to the violation. You should be able to present evidence as to the association being harmed or potentially being harmed. And you should be able to show that you placed the owner on notice that the violation would have dire consequences. So, I'm back to that word again. I'm looking at the time. I'm back to that word again, notice. Notice in court is very important. Either notice that you should do something, notice that you shouldn't do something, or notice that I would never know that this is a possibility until it actually happened. So before you run out to go hiring a lawyer for an injunction action, you want it to be a serious issue. Could you file an injunction action over weeds? I guess you could find an attorney. I mean, if the weeds are, well, bad example. Could you find an attorney to file a lawsuit regarding leaving a trash can out 6 hours after it should be placed in? Sure, you could. Should you? No. Find another way to work with that owner. There has to be a way to work with that owner outside suing them. Now, that being said, I file a lot of injunction actions, a lot of them. Most of the time, the injunction actions I file is because owners do not respond to the association or to me or to anyone. Sometimes they'll get served with the lawsuit and they'll just say, I didn't know, so we'll work a deal out, they'll come into compliance, and everyone's happy. Sometimes they'll say, I don't care, then I have to prove the damages, and I would have brought the lawsuit unless I could. And we get the judge to order them to bring themselves in compliance, and life's good. Or they don't respond to the lawsuit at all. I get a default judgment, and we have to figure out some way to enforce it. But injunctive relief, my friends, is not something that you enter into trivially. It truly is something that you should enter into thoughtfully. The next and last enforcement mechanism is self-help. Only can be used if the CC&Rs allow it. And I get a little nervous when it comes to self-help. I'll give you another example. The community association, their CC&Rs say that the association, after giving adequate notice, can go onto an owner's property to maintain the property and charge the cost back to the owner. Okay? The owner, all of the front yards in the association are desert landscape. Okay? This house has weeds up to my knees, and I'm 6 foot tall, so those are probably 3 or 4 foot high weeds. Okay? No sign of life in the house. No sign of life whatsoever in the house. Association comes to me and it says, Augustus, we got to do something about this. You know, the house, 2 houses near it are for sale. You know, these people are saying that owners are leaving because of this house. You got to do something about it. We want to use self-help. And I say, okay, make sure you provide the proper notice. Okay, we send them letters. We actually go post something on the door saying, hey, we're going to come and maintain your landscaping. no one ever comes out. And so we did all the notice, we placed something on their door, we went out there and we landscaped the property and no one's there. We kind of peeked in the windows and the place is empty and no one's there. And so we just maintained the landscaping and we left. Great. That's how you do self-help. This is how you shouldn't do self-help. Hey, Augustus, it's a desert landscape community. The weeds are up to your knees, but there's kids playing all over the house, and the guy comes outstairs on the front porch and polishes his handgun. You know, he takes apart his M15 and puts it back together. We want to go use self-help. Oh, and by the way, the guy comes to our HOA board meeting and yells at us constantly. We've had to have the police come and escort him out. We want to use self-help. And I say, in that situation, I would go get a court order first. I'd get an order from a court saying that you have a legal reason to be out there. Well, Augustus, what kind of lawyer are you? The CC&R say we have an easement to go and impose self-help. Yeah, see, we're going to do it anyway. Okay, here's my written opinion. Good luck with it. 3 days later, I'm trying to eat my lunch. Augustus, what, Mary, my paralegal? Augustus, this board president's on the line. He says that there's police and SWAT teams, and people are yelling and screaming, and he's afraid that people are going to get hurt. I'm like, whoa, slow down. What are you talking about? Well, they sent their landscaper out there to do self-help, and the guy came out with his M15 and started pointing it at him. They called the police, and he went back into the house. And when the police got there, no one was out there, and the landscaper was trying to do the work, and they said, "Police, go in there and make him do the work." And the police said, "We don't enforce restrictive covenants. What are you talking about?" They want to know what to do. Self-help should only be used when a property is abandoned or no one lives there. Why? Because you never know who's on the other side of that door. You send your landscaper out to effectuate self-help, and the guy comes out or the gal comes out with a baseball bat. You send your landscaper out. This is the more prevalent example. You send your landscaper out to do self-help, the owner calls the police. There's some nut job on my property hacking up my bushes. Just hacking up my bushes. I'm scared. He could be coming to my house next. The police race to the property and put the landscaper in cuffs and stun guns the other landscaper. Because the other landscaper is coming towards the police with shears saying, "What? What do you want?" So stun guns the other landscaper. And while the stun gun landscaper's in cuffs and the other landscaper's in cuffs, the board president comes by and says, "What are you doing?" Well, the owner said that these people was on her property chopping down her bushes. Well, of course, we sent them there. What do you mean you sent them there? Well, we're exercising self-help. What is self-help? It's this provision in the CC&Rs. CC&Rs? I see a man with shearing shears coming at me with shearing shears, and I see another guy yelling at me saying, "What? What do you want?" We took him down and arrested him. Do you have a court order saying you can be on this person's property? Well, no. Well, then why are you on their property? It's called trespass. Police have a lot of things to do. They don't want to deal with the landscaping crew when someone calls them and says, "I'm scared. I'm 68 years old and someone's coming on my property. I didn't tell them to come here. They're cutting my bushes. I don't know what they're going to do next." Real life examples. So if you're going to use self-help, 1, provide the adequate notice, and 2, save yourself from being put in a bad situation or your contractor from being put in a bad situation. Because you don't have to use self-help. You can use injunctive relief. Most people use self-help because it's quicker and it's easier. But if you're going to be challenged on it, then go the injunction route. I've gotten many courts to say, "Hey, I will give you an order I will reinforce your easement to go on the property to effectuate self-help. Do you know what that court order does? It allows you to call the police. It allows you to call the sheriff and say, on Monday at 5 o'clock, pursuant to this court order, we are going to remedy the violation. We're going to trim the bushes. So with that, when the owner calls the police at 5:10, the police know there's a court order, they know who's out there, and it won't be a stun gun live PD episode. I love live PD, by the way. My son and I, we play golf on Friday afternoons, we grill a big steak, and we watch live PD. It's wonderful. So that's self-help. Only use it when the property is abandoned. Make sure you provide proper notice, and just understand that, just understand that you don't want to put yourself in a confrontational position when using self-help. All right, we are on time. I love it. Now, quickly, I will get the following situation. I moved into my association about 2017, and I decided that my son, who's now a golfer, was going to be a basketball star. So I put in a basketball hoop on the front yard, right? Clearly illegal. I know this. CC&Rs say no basketball standards, but I'm the HOA guy. So I put a basketball standard up. And that standard stays up for the following 8 years. 8 years. Then my son says, you know what, Dad, I don't want to play basketball. I like going to play golf with you. I think I want golf to be my sport. So okay, I'm not going to play basketball anymore. Okay? But I leave it up because I'm lazy. The HOA 8 years later sends me a letter saying, you violated the restrictions. You need to remove the basketball goal. Well, I'm the HOA guy. I'm a smart, you know what? So I say, well, wait a minute. It's been up for 8 years. You have waived your right to enforce this provision against me because you've allowed me to violate the restriction for more than 8 years. Right? Makes sense. If you're in violation of the law, if you kill someone and the police don't come after you for 20 years, they can't come after you. No, there's no statute of limitations on murder. And there's no statute of limitations on violating the restrictions so long as your CC&Rs say that. This is called the concept of waiver. Oh, no, too many buttons. Sorry, TV land. Sorry about that, TV land. This is the concept of waiver. And this was specifically addressed in a court case before the Arizona Court of Appeals. And it says that so long as the CC&Rs or the declaration, so long as that document contains a non-waiver provision, then the restrictions in that document remain enforceable regardless of the passage of time. Regardless of the passage of time. So, if you violate the restrictions and it lasts for a year and you thought, hey, I got away with it, but then you get that letter from the HOA and the HOA says you got to remove it, you want to look at your declaration or your CC&Rs to see if you have a non-waiver provision. If you have a non-waiver provision, you're stuck. It's kind of a situation where there is no statute of limitations on a violation. They can enforce a violation so long as they've provided proper notice. Because remember, you always have to provide the owner with notice. So for those of you in TV land that say, hey, I've had that storage shed for 10 years, and now the HOA wants me to remove it, they can't tell me to remove it, they've waived their rights to enforce, you might want to check out the case on the screen here. Call your attorney and see if it applies to you. And it probably does. So, I would like to thank the City of Scottsdale for allowing me to teach these wonderful classes. It's been 10 years. I've been teaching these classes for 10 years with the City of Scottsdale, and I really appreciate the opportunity. I hope everyone in the audience and you all on TV land got some benefit out of it. Please, 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 fill out the surveys. And for you guys in TV land, I guess call the city. The only way I improve is if I get feedback. Now, if I am perfect, then, hey, I'll just be perfect. But I'm sure there's something that I can improve on. So thank you for watching. Thank you all in the audience for attending.